Good morning or good afternoon, everyone. Welcome to today's webinar. Before we officially begin, we do have a couple of quick housekeeping announcements to get taken care of. The first announcement, you might have noticed that you're currently in listen-only mode. This is to ensure that everyone can hear our fantastic guest speaker and that we can make sure there's a minimum amount of background noise. However, questions are welcomed during today's presentation. We would be delighted to weave your question into the flow of the conversation. To ask questions during today's presentation, on your screen, you should still have the pop-up from GoToWebinar. On that pop-up, there is a button labeled Questions, and if you enter your question there, we'll be able to see your question and set it up for response during our presentation. So again, questions are welcomed during the entirety of today's presentation, and we'll ensure that there's a small question and answer session towards the end of today's session. Our second announcement for today. Today's session is available for CLE credit for Delaware. If you are interested in ensuring that you receive CLE credit for today's presentation, when you signed up for today's webinar, you should have entered your Delaware bar ID number as part of your registration. If you did not complete that field, we cannot provide a certificate with your bar number on it. So please ensure that you have entered that information. And if you have not, please send us an email to support, that's SUPPORT @fastcase.com, so that we can ensure that you receive the proper certificate and credit for today's session. All right, so now that we've gotten those fun housekeeping announcements out of the way, my name is Erin Page. I'm the Senior Law Librarian on staff with Fastcase Legal Research, and joining me is Morgan Wright. Morgan, would you like to introduce yourself?
Sure. My name is Morgan. I'm the publisher at Full Court Press, which is Fastcase's publishing imprint and arm. Earlier, well, I guess about 2 years ago, we acquired Mr. Kropp's book, and we put out a new edition just last year, which is the topic of this webinar.
Fantastic. So without any further ado, I'd like to introduce our wonderful guest speaker for today, of course, Mr. Kropp. Mr. Kropp is a wonderful practitioner in the field of real estate practice. He is the director of Richards, Layton & Finger, of course, Delaware's largest law firm, and has been a vast practitioner and expert on the field. And we are just delighted and thrilled to have him join us. Hello, sir. It's good to have you with us.
Thank you, Erin. Thank you, Morgan. What better to spend a snowy day in Wilmington than talking about real estate law?
I agree, but that might make me a nerd. I'm not sure. But let's go ahead and get started officially. Can you tell us a little bit about yourself, background-wise, education-wise, any large cases of note that you think that's important for everybody to know about?
I've been practicing commercial real estate law since 1983. And it's really, you know, I worked a little bit after law school, so I won't bore you with the details, but I was a late bloomer, let's put it that way. So I came to the law later in my life after a couple other careers. But since 1983, I've been doing a whole gamut of commercial real estate work, all sorts of things, but lots of finance work for both borrowers and lenders. You know, I think that real estate is an enjoyable practice of law because you can see the tangible evidence of what you've done on the ground. You can look at apartment buildings that you've worked on, office buildings, shopping centers, stadiums, manufacturing plants, and that kind of tangible evidence, I think, is what makes it special for real estate lawyers. I know most real estate lawyers feel the same way. One of the other things I did early in my practice was litigation, real estate litigation, and I think that really helps because then you can see what goes wrong in a transaction or in the documents. Fortunately, never in one of my transactions or documents, but other people's that we had to work on. Apropos of our topic today, I think one of the interesting litigation pieces I dealt with early on in my career was a case where there were claims of a subordinated purchase money mortgage holder that the construction lender had failed to pay attention to disbursement of proceeds or in the course of construction, and that as a result, owed a duty to the purchase money mortgage holder who was in a subordinate position, owed a duty to that subordinate lender such that the priorities of their lien should be reversed. Interesting case, and I think I might touch on it later, so I'm not gonna tip my hand on where that came out.
Well, we'll suspense then.
And as far as the book, what first, drove you to write? I mean, it's not easy to write this type of book from the ground up. Certainly, it's getting more and more difficult to find authors that are willing to undertake a project like that. What was your main motivation for starting the book?
Well, I've been, as I got more senior in my career, I was spending more time in supervising and mentoring other lawyers, and had developed a lot of training materials and informational materials. And I thought, okay, well, I've got this stuff. What am I going to do with it? And then I was thinking, I'm getting closer and closer to retirement, and so maybe I ought to pass along some tips beyond those I give to the lawyers in my own law firm. So putting those two things together, I thought, well, I'll put together a publication of some sort. And there really isn't a lot out there on Delaware real estate law, aside from occasional CLE presentations, which are often good products. But there's no one place where you can take a look at a variety of issues in Delaware real estate law. So I thought, why not pass along tips to my colleagues in the bar before I retire?
Fantastic. One last question about kind of a background thing before we get into the meat of today's presentation, and that is, who would you say would be the ideal reader, or who would you directly recommend this type of book to? And is there a real life example that you would like to mention where a book like this would have helped you in your practice?
Yeah, I'm not sure there's a particular ideal reader. I pitched the book to what might be seen as intermediate level stuff, giving some basics, but then touching on some advanced things without getting into the weeds of the truly advanced. For example, I touch on interest rate hedging contracts, but I don't go into the same depth that would be in a treatise for really advanced stuff. So I'm hoping it'll be useful in training new lawyers, in helping general practitioners, but also be a resource for seasoned real estate lawyers. I know there are gaps in the book, and I'm hoping that those will be filled in maybe in later editions. And I'm expecting that my colleagues, certainly in Delaware, won't be shy about passing along suggestions for other topics to include. As to a real life example, I'm not sure that quoting from my own book would have ever made a compelling argument in a negotiation. But I do know that at least one of my colleagues has used some of my analyses on opinion letters in pushing back on opinion requests in a deal, particularly on no violation opinions, which is a topic I hope we get to today.
Fantastic. Well, with that in mind, let's dive headfirst into the topics. So first off, your book has so many topics and so much content in it that I know we're not going to cover even a fraction of what you wrote. But one of the things you begin with towards the beginning of your book is a discussion of mortgages, which is, of course, one of the most common means of securing any obligation. And you begin that discussion with the discussion of promissory notes. So you mentioned that a negotiation of a note to a purchaser in good faith or a holder in due course permits that holder to take the note free of defenses that would have been available to the maker of that note against the original obligee. So tell us a little bit about some of those defenses, and if there are any limitations that can be worked into the note to avoid the loss of those defenses, anything related to that, kind of a fun twist there on the mortgage note.
Sure. Negotiability is governed largely or generally by Article 3 of the Delaware UCC. And as most of the folks probably listening in know, that a promissory note is negotiable when it's an unconditional promise to pay a fixed sum, payable to the bearer or order, payable at a definite time or on demand, and particularly doesn't include any other undertakings or instructions other than the payment of money. Those are all important elements in negotiability. For example, a loan agreement has been held not to be a negotiable instrument because, in fact, it never included a promise to pay. It simply included the terms of payment, but was not an unconditional promise to pay. Delaware law permits a negotiable note to include certain other undertakings, but they're fairly limited. So, for example, you can include confession of judgment or waiver of lien, or an agreement to provide collateral to secure the note, still have it negotiable. But on the other hand, you have too many conditions and your note becomes unnegotiable. So, for example, subjecting the condition to payment to some other document, like a loan agreement, could make the note no longer negotiable. It's okay in certain circumstances, but generally, you're going to be careful of that if you want a negotiable note. So negotiability is largely a drafting matter. As you point out, if the note is negotiated to a holder in due course, a purchaser in good faith, then there are certain benefits to that purchaser. And why is that important? That's important because the note may have greater value to a purchaser of the loan, therefore may command a higher price or at least a lesser discount off the note if in fact it's negotiable. So that concept of free from defenses, largely, there are a lot of details in this without getting into the weeds, but largely what you're talking about is free of the initial contract defenses that the obligor, the maker of the note might have. And so the holder in due course will take free of those kinds of things, breach of contract, failure of condition, those sorts of defenses that might otherwise have been applicable against the original holder. So it does have value. It is really a drafting matter. I think most of us recognize that there are a whole lot of notes out there in general use in commercial real estate that are simply non-negotiable because they do refer to extrinsic conditions to payment. So it depends on what the holder has in mind with that note and whether they want to make it negotiable, keep it negotiable for their own purposes of selling it for a higher price.
On the topic of usury, you explained that Delaware law permits wide-ranging exceptions to the maximum interest rates permissible for corporations, limited partnerships, statutory trusts, and limited liability companies, and also takes the unusual step of extending those exceptions to individuals who are guaranteeing the promissory note, so long as the mortgage securing the note is not the primary residence of the guarantor. Are there any steps that a guarantor can take to limit their exposure to these possibly extreme interest rates, either for the original promissory note or in relation to any increase as a result of default by the corporation on the note, short of not guaranteeing the note in the first place?
That's about the only thing you can do. Don't guarantee the note. I don't think there's really any drafting solution. And let's, fortunately in Delaware, usury is in such limited circumstances. It doesn't become as, it's not a practical issue, generally speaking, in Delaware with Delaware courts and Delaware loans, because most commercial real estate loans don't fall into the requirements for when usury is even going to apply. But, usury, we all know, means that it's direct or indirect payment by the borrower to a lender at an interest rate that's higher than permitted by Delaware law. The types of, Delaware, as you say, has this savings clause that certain types of entities, such as LLCs, can't even assert a defense of usury. And Delaware courts have clearly held that a guarantor for the debt of such an entity cannot raise that defense either. So can you draft around it? I'm not sure you could. Number one, a lender's never going to agree to limitations because they want the guarantee. But because usury applies as a matter of law, it's hard to see how you could draft around that. The one caveat I will give you, however, is that the inability of an LLC, for example, to assert the defense of usury could be seen as a procedural limitation, not a substantive. And so I've always been curious, in litigation in a different jurisdiction, for example, would a court necessarily apply that exception to the defense in their jurisdiction as a procedural matter, and might simply ignore that and say, well, sure, an LLC can raise a defense under whatever, Illinois or whatever, choose your law. So that's one thing I think to keep in mind. The other thing to keep in mind, I think, with usury and drafting, and here is something that can have some drafting implications, and that is the usury savings clause. Most notes or agreements that are concerned about usury will include some provision that in the event that the loan terms are found to be usurious, that any interest payment beyond the legal limits will be deemed to be treated as a principal payment. And it seems like an elegant way to get around usury, but there are cases out there saying that that's not an effective way of avoiding usury. That because usury is a matter of law, if it's usurious, it's usurious, and it's occurred, and it can't be simply reversed by drafting around it. So, bottom line is, if usury applies in Delaware, good luck with the usury defense. If you're in a different jurisdiction, be aware of the fact that maybe that limitation might not apply. And when you're drafting your notes, keep in mind that the savings clause for usury, might not in fact save you.
Excellent. So moving a little bit off of usury, but still in the area of interest and interest rate. And again, this is something that has been mildly scandalous in the news, although less so this year. There have been in the past a bunch of scandals regarding LIBOR and the various manipulations that people have done using LIBOR. So the index is being discontinued as a result of that process. Discontinued in 2021, of course. So one of the suggestions, and you do go into this in a bit in your book, one of the suggested replacements for the LIBOR rate in the determination of the interest rate is the secured overnight funding rate, or SOFR. And that's, again, proposed as the leading contender to replace LIBOR in these calculations. Can you tell us about some of the benefits of using SOFR? What are some of the major drawbacks for it? And do you have any advice for practitioners looking to prepare their current clients for this changeover?
Sure. This is a complicated topic, and I don't want to get too much in the weeds as well on this one, but just to back up a little bit, just in case there's someone listening in on this that are not as up to date on the situation with LIBOR and SOFR and the rest. I mean, everybody knows LIBOR is the index rate. The London Interbank Offered Rate's been used as an index for quite a while now. And I think most practitioners know that it's a purely fictitious rate. In other words, it's not something that a regulator has set up as a rate to be used in commercial real estate, let alone other kinds of financing around the world. I mean, it's really the rate that a specific group of banks say they will charge to lend to another one of those specific banks for a specified duration, like 30 days. It's not even the amount they will lend, it's the amount they say they will lend. So you have these banks coming together and coming up with, oh, today this is what LIBOR is going to be for 30 months or 30 days. As you note, the scandals after the Great Recession really has put paid to LIBOR, and it will cease to be existing as an index sort of between 2021 and 2023, depending on the duration of the LIBOR rate that we're talking about. But obviously, lenders have already started the process of transitioning from LIBOR, and if they haven't, they really should have. The problem, as I said, it's complex because there's no single authority to create a new index. Since LIBOR itself wasn't created by some specific authority, the replacement index has to come up from some place, and it has to be as easy to use, and it has to be as safe, or so everybody thought it was safe, as LIBOR. It also has to be an index that's easily transitionable from LIBOR. And probably, and I'm going to mention this a little bit later, it has to be an index that works not just for commercial real estate, but that also works in the area of derivatives and warehousing and securitization and all the rest of it, because those two rates these days fit together. They have to be the same, or else lenders will tear their hair out. the lending industry has developed around, in the US at least, there's a couple different rates that have come up in different geographic areas around the states, but the front runner has been SOFR, because it seems to have legs with both the lending industry and the regulators. Now, for those who don't know SOFR, it's the rate that reflects how much it costs to borrow cash collateralized by US Treasuries on an overnight basis. So, it's thought that this would be a simple rate to publish and use. But there are a lot of problems, or challenges, I shouldn't say problems, but certainly challenges with SOFR. First, it's only been published since 2018, so it doesn't have a track record. It can be a volatile rate, more volatile than people maybe want. And it's a rate for a secured loan because it's secured by US Treasuries versus an unsecured loan, which is LIBOR. LIBOR is simply a rate for unsecured borrowing. So because of that, one would expect that a rate for secured obligations is going to be lower than that for an unsecured obligation. So there's already a disconnect probably between LIBOR and SOFR for that reason. So if you're going to replace LIBOR with SOFR, it means you've got to adjust. You've got to adjust to reflect that difference of risk between secured and unsecured obligations. So in other words, simply substituting, plugging in SOFR for LIBOR in a note can have some unfortunate effects that need to be adjusted. On the other hand, I'll note that most notes that are out there that are LIBOR notes will also already provide that in the event there's no longer a LIBOR rate to use, that the rate will now be prime. And SOFR can't be as bad for the borrower as reverting to prime rate in place of LIBOR. I mean, if you think about it, LIBOR last week was 0.15. Wall Street Journal Prime was 3.25. If your loan is the index plus 200 basis points, you can see what the effect would be on the borrower if it simply reverts automatically to prime, as is the case under most of these notes. As I said, one of the reasons for adopting SOFR is because the derivative industry likes it, and it's sort of easily adopted by them. And because commercial lenders need to have that consistency between their derivative desk and their lending desk, the rate really has to be the same, which is another reason why lenders, I think, are gravitating towards SOFR. The same group that came up with SOFR, which is a committee that was created by the New York Fed, also has issued recommendations for how a lender can adjust the spread in transitioning from LIBOR to SOFR in order to keep the resulting interest rate comparable. So there's already some material out there that, again, most of the large commercial lenders are looking at and using. The US regulators on November 30 advised banks that continued use of LIBOR without robust fallback provisions can create safety and soundness concerns for that lender. And something a regulated lender never wants to hear is that there's safety and soundness concerns with its bank. So lenders are really in the process of making these adjustments for both existing and future loans. But the clock's running out if the lender is not on top of this already and addressing it with its borrowers. Most larger lenders have standardized language now that they're putting in place with existing loans or in future lending to give you the path forward with what will happen when LIBOR is not available. There are some lenders out there in the States and the US who are already lending not on LIBOR but using other indices, not necessarily SOFR. From the borrower's standpoint, the great concern is, what's my bank going to do if LIBOR is not there? If my loan doesn't mature before LIBOR is no longer there, I'm going to look at my note and see that I revert to prime, my index reverts to prime, and be greatly concerned about what my interest rate is. So it's really time for conversations between lenders and borrowers if they haven't started already. And again, most large lenders have started those conversations.
Moving on to choice of law to close out the section on mortgages. You mentioned in your book that Delaware has two choice of law traditions that are applied in contracts, the common law and a variation on the second restatement of conflicts. Tell us a little bit about what distinguishes these two provisions, and is there any direct advice to ensure that a choice meets both possible tests?
there's probably not a lot of substantive difference. Delaware Supreme Court decisions have said that Delaware generally honors the law chosen by the party to govern a contract, including a promissory note, so long as the selected jurisdiction has a material connection with the transaction. But trial courts in Delaware have tended to look further to the multi-pronged restatement test. The two approaches probably in most cases are going to lead to the same result. But the restatement approach, of course, requires more analytical steps. Restatement being chosen law will be honored unless the chosen state law has no substantial relationship to the parties or the transaction, and no other reasonable basis for this choice, or that the application of the chosen law would be contrary to a fundamental policy of the state with a materially greater interest in the determination of the issue, and would be the state law absent the party's choice. In both cases, if you think about it, the choice will generally be enforced because if there's a material connection with the transaction or the parties. But as you can never be certain in which jurisdiction you're going to be when this is litigated, I think most people try to make sure that they're choosing a law that would fit within a restatement test for that reason. You might be in a jurisdiction where they follow the restatement wholly or only follow the restatement. So you're going to want to make sure that your choice fits within those various prongs. Even better yet, you're going to have in your contract that Delaware is the venue for all disputes, so you're going to be in Delaware, which is probably more likely to choose to enforce a Delaware choice of law. And then finally, in addition to the common law tests, Delaware has its statutory basis for parties to choose Delaware law to govern a contract, generally applicable to contracts for $100,000 or more. And there's some other tests, but you expressly elect Delaware law, make sure your parties are subject to the jurisdiction of Delaware, and make sure that they can be served. And then you're going to have Delaware law apply to your contract.
Perfect. So just pivoting just slightly from mortgages in general to a little bit more specific information about the mortgage itself. One of the things that you mentioned in your book are a couple of unusual mortgage types. So beyond the ones that people think about in a traditional day-to-day practice, one of those types included what was known as a leasehold mortgage, where the mortgage is guaranteed by a lease instead of the land itself or the property that's a part of the land. And in that description, you go into a long list of restrictions and documents that should be provided by the lessee to the lender. Can you tell us a little bit more about this rather unusual mortgage type and how it kind of works in a real life context?
Yeah, Delaware mortgage law is pretty simple and pretty straightforward in concept. I mean, a mortgage is what? It's a mortgage is an agreement to allow the mortgage holder to sell the real estate collateral to pay the secured obligation, and a mortgage can be one sentence long, so long as it secures a real obligation, whatever that's promissory note or a promise to perform something or an obligation to a third party. Leasehold mortgages, though, have some important peculiarities that are both legal and practical. Those who are listening in on this who are familiar with Delaware leasehold mortgage law know that under Delaware law you can only mortgage a leasehold interest if the term of the lease is at least 10 years, and that 10 years dates from the initial date of the term, not from the date of the mortgage. But when there's a lease rather than land as collateral, there are a lot of things that you're going to want to do in your mortgage instrument or in some document between the lender and the borrower. Obviously, the collateral is not the dirt. In a leasehold mortgage, the collateral is the lease itself. So it's not the land, it's not the improvements, it's the leasehold interest in those things. So what's that? You've got, my academic side gets me in the weeds, so I will try desperately not to do that. But a lease, contains both contract and possessory interest. So you're dealing with both of those as your collateral. So the leasehold mortgagee wants to know that it has collateral. There's a quote in Friedman on leases that a mortgage on a lease is like a mortgage on a balloon. Prick it and it's gone. A lease can disappear in an instant, and then there's no collateral for the mortgage. So leasehold mortgagees looking at what does the lease say, how does it exist, how can I ensure that it will continue to exist consistent with my expectations. So that leads to a lot of provisions, generally speaking, that you're going to include in your loan documents, or certainly, as I'll mention in a minute, in the lease itself. So Lenders Counsel is going to be looking at a lot of stuff on the lease. Borrowers Counsel is going to be making sure that the lease actually satisfies what a lender is going to require. And this is a topic that I could probably talk about for an hour, but I won't. So just some highlights. So this may be fairly general, and I apologize for that, but there's no way to do it in any detail. Fundamental key element is the obvious one. You need to make sure that the lease is financeable. So the borrower entering into the lease, the borrower's counsel negotiating that lease, the lender's counsel looking at it from the standpoint of the financing. Is it a financeable lease? There's some obvious things. The lease term has to be as long as the loan term, right? Because if it's less than that, the collateral disappears in an instant. But there's also some add-ons to that. For example, if the loan does not self-amortize during its loan term, the lender may also want assurance that there's enough time on the lease term after the loan matures that another lender is going to actually be willing to step in and refinance the loan. Because I might have my balloon after 5 years that has to get refinanced. If there's only 6 months left on the lease or even a year left on the lease, how do I know that the borrower is going to be able to finance that balloon payoff? In addition, some lenders may have regulatory requirements or internal policies for the length of term that they have to accept. Leasehold mortgage is going to include various statements by the borrower about the lease, its term, its status, the promise to pay the rent and comply with the various lease terms under the lease. But more importantly, the mortgagee is going to want the right to step in and cure the defaults of the lessee borrower if that person fails to satisfy its requirements under the lease. And then, of course, add any curative payments to its indebtedness. The leasehold mortgagee will also expect the borrower to keep the mortgagee notified of defaults, whether by the lessee or the lessor, copies of default notices, notices of elections, like notice of election to exercise an option. The borrower will promise, importantly, not to modify the lease because, again, the lender is lending on the lease as it existed at the time of the loan, so doesn't want to have materially adverse modifications to that collateral, and importantly, no termination. So there will always be the prohibition on termination, which seems kind of obvious. Requirements to get estoppel certificates and a lot of other bells and whistles that you're going to be throwing into the various requirements. The lender will want the right to have a new lease. If the lease is going to disappear, for example, if the lease is rejected in a debtor's bankruptcy, borrower debtor's bankruptcy, the lender is going to want to have a new replacement lease in place to take that on. And finally, most importantly, the borrower will promise not to consent to the subordination of the lease to anything that's going to expose it to being wiped out by a foreclosure. So, for example, there can't be a subordination to a fee mortgage because otherwise the fee mortgagee forecloses on the fee, wipes out the subordinate leasehold mortgage. So all of that tells you there's a lot of stuff in the mortgage, but it's more important that the borrower up front have negotiated a lease in the first place that is financeable and will satisfy a lender's collateral requirements.
A bit more on that topic of collateral. One of the more complicated collateral situations involves condominium projects, especially when the project is foreclosed upon before the full project is built out. Tell us about the interaction between the Unit Property Act, otherwise known as DUCIOA, and any major considerations that a person purchasing a condo should be aware of in regards to these projects.
This is another wonderful complex question that we can only skim the surface of. but at times you've got the collateral for a commercial loan is going to be condo property, and this can take the form of existing condominium units, land being developed for a condominium project, or portions of an incomplete condominium project. In Delaware, again, listeners who know Delaware law know that condominiums are created and governed by either the old Delaware's Unit Property Act or Kiowa, more recently the Delaware Uniform Common Interest Ownership Act, or both. Now, Kiowa applies with a few exceptions to all common interest communities, which would include condominiums, including those in existence when Kiowa was enacted. For commercial condominiums, Kiowa generally doesn't apply unless you elect it to. So, in those cases, in a commercial condominium, there aren't lots of them, but in one, you're going to be looking at the Unit Property Act, generally speaking. So, in a condo, we all know that you have two kinds of property, right? You've got a unit or a common element subset of limited common elements. But that's essentially a common element, and there's nothing else. You have a unit or common element, and likewise, until a unit exists, which means that relevant improvements have been completed, and in some jurisdictions, in local jurisdictions in Delaware, a certificate of occupancy has been issued, those improvements don't necessarily constitute an independently transferable or mortgageable real property interest. So the really interesting issues to me arise when you're financing an incomplete project. That is, where not all the potential units have been completed and sold, because that relates to the nature of the borrower's interest and what are you getting as a mortgagee. So, for example, you have a condo community originally planned for 100 residential units, and only 50 have been completed and sold to home buyers before the foreclosure of the construction mortgage. So, what is it? What's the foreclosed property being purchased at that foreclosure? It's not 50 lots of land, because the land hasn't been subdivided into lots, even though most of us know our developer clients think of it as lots. They're not lots. So there's nothing that exists. The units don't exist as lots. They're not units, those other 50, because they haven't been built yet. So they're not units. You're looking at the loan docs and the Kiowa or Unit Property Act to see what is it, in fact, that real property is. And it's going to be some variation of the following in almost all instances: that the purchaser at the foreclosure acquires title to the land and improvements that exist, subject to the interests of all the existing unit owners in their own units and in the common elements, both those that exist at that time and those in the future. And so that's what you're getting, right? But what does that really mean? What rights does the new owner at foreclosure really going to have? And this is important for the lender doing the financing, because that's what they're looking at. They're looking at, what are the rights that I would get if I have to take this loan back, or if I've got to sell it in a foreclosure sale? Who's going to buy it, and what are they willing to pay for it? So, what do the documents say? Is the entire property subject to declaration, or are there specific sections that are subject to declaration and the rest of the potential project are not? What is that remaining property that would come into the project? Do the documents allow for that additional property to be added to the project? Does it have to be added to that project? What kind of disclosures have been made to unit home buyers about what the ultimate project is going to look like? And is any future developer stuck with a particular kind of project? They can't change it in the future. So in dealing with these kinds of issues, you really are trying to pay a lot of careful attention to what the documents say in terms of, what is it that you're going to have to develop if and when you have to take this on in a foreclosure. There's an interesting case a couple of years ago in Bethany Marine Townhouse Phase 2, where the Delaware Supreme Court held that, in a summary judgment ruling, that the developer retained the right to construct improvements free of the condominium declaration on lands designated for future units. The developer in this case had purchased all the original developer's rights to the condo project and to lands not yet submitted to the condominium. And it's an interesting case. If you haven't read it, you really should if you're in this space, because it gives you some guidance on this issue of how to deal with structuring the condominium as collateral in the event it has to be foreclosed in the future. And I won't go on in the case. I've got my own thoughts on that particular opinion, but it is what it is, and regardless of my views on it, the Supreme Court has spoken. But the second thing to think about is not just the dirt and that you're buying, but what rights you have to develop the acquired property as part of either the established condominium community. Again, much depends on the applicable condominium documents. But if you think about it, if the right to develop the property, let's say the right to add units and to expand the condominium and all the various things that the developer wants to do and that you, the lender, are getting as collateral, that generally the right to develop the community is inherent in the rights of the person who made that declaration and reserved the right to build, which is the declarant. These are so-called declarant rights or special declarant rights or reserve development rights, and a variety of different names used, particularly in Kiowa. But the right to develop, to continue to add units, isn't a statutory right. It's not inherent in the real property. It's not by virtue of ownership of the real property. It's a right that's in the declaration and inures to you as a contract right. So therefore, if you're if you're trying to figure out what are going to be my rights if I have to foreclose on this, you can't lose sight of the fact of how do I get those rights to actually expand. If you look at it from a purely legal standpoint and think about it, those are contract rights. Those are Article 9 of the UCC rights. And so how do those get from the original declarant, who's now gone, through the foreclosure to the new buyer who wants to expand the condominium? Now, Kiowa has made that easier because it provides for generally a statutory transfer with, you've got if you're the buyer at the foreclosure, you have to opt to take various rights and various liabilities. But there is at least a statutory basis that did not exist under the Unit Property Act. So, interesting question.
Thanks for your detailed answer there, and also how to pronounce the acronym Kiowa, which was not how I predicted it would be. But moving on to the topic of priority of liens, your book describes many different priority orders, including statutory, mechanics liens, and other lien types that automatically have priority in specific contexts. However, equitable subrogation can wreak havoc on the normal priority order so long as the requirements are met for the claim. Tell us more about these requirements and what impact does the case of Eastern Savings Bank have upon this type of action?
Yeah, priority in Delaware is pretty easy. First in time, first in right. There are some exceptions to that. There are mechanics liens or governmental liens or association liens or express subordination, that sort of thing. And purchase money mortgages. Just as a reminder to the listeners that in September, the law on the priority of purchase money mortgages was changed in 3 important ways. Purchase money mortgage now includes any mortgage to secure a loan for all or part of the purchase price, not just one back to the seller. Second, it has priority not just over other mortgages, but over other liens, such as mechanics liens. Although I query, what about governmental liens, and how's that going to work out? And third, to get this favorable treatment, you have 10 days to record that mortgage, not just the 5 days under the existing law. So anyway, back to equitable subordination. I mean, the idea is that there are events that can cause subordination through the concept of subrogation. And the interesting case from a couple of years ago was the Eastern Savings Bank case versus CACH. The concept of equitable subrogation is that the mortgagee who funds the payment of a senior mortgage is subrogated to the senior mortgage holder, and therefore arguably steps into the priority shoes, if you will, of that repaid loan. It's a topic that a lot of law professors like to talk about. I think in some jurisdictions there's law on this saying, yeah, you're subrogated as in any other subrogation situation. The Delaware Supreme Court, however, said that, in a nutshell, absent other equitable conditions, such as unjust enrichment, equitable subrogation doesn't apply to a normal mortgage refinancing. The idea here is that in a pure race recording or race priority state like Delaware, should a lender who wins that race to the courthouse, or a lien holder who wins the race to the courthouse, knowing that there's another lien holder about to file, should they get that priority simply because they won the race? And the court pretty much said, yeah, I mean, that's the right answer unless there's some underlying equitable issue. In this case, and by the way, equitable subrogation in Delaware has been around for 100 years, largely in bonds and that kind of thing, payment and performance bonds. So it's not a new concept in Delaware. It just had never been applied to the concept or to the context of a mortgage refinancing. Interesting facts in Eastern Savings Bank, you've got a debtor who had all kinds of liens of all sorts. One of its creditors gets a judgment in common pleas, and then almost literally the next day, but let's say a day or so later, the borrower, the debtor, refinances with Eastern Savings Bank to pay off all these various liens other than the lien holder in common pleas. Before Eastern Savings can record its mortgage, the common pleas judgment creditor transfers its judgment to Superior Court, so it's now a lien on the property. And of course, the mortgage is foreclosed. And the judgment creditor says, wait a minute, we're first in priority. We get the proceeds, not you, Mr. Mortgagee. And the court pretty much said, yeah, that's what happens. You lost the race. There's no equitable subrogation in this, so too bad. Anyway, that's equitable subrogation in a nutshell.
Excellent. Well, turning from subrogation to another due diligence thing that is involved highly in mortgages, let's talk about third-party opinions. So the major type of third-party opinion is, of course, the ones that you get or that you seek in relation to the mortgage that look to the status of an entity, or that look to the legality of a particular mortgage, or the remedies that would be involved within these types of mortgages. Can you give us a couple of examples of when a particular lender or a particular borrower should seek this type of third-party opinion? Are there direct circumstances that you would consider such opinions to be a mandatory part of an ethical practice? Are there certain circumstances where a third-party opinion is a waste?
The opinions are an interesting, they're interesting topic, and they're a particular favorite topic of mine, I guess because of my opinion nerdiness or something. And in fact, I think the book, the longest chapter in the book is on opinions. But generally speaking, entity opinions in Delaware, in almost any jurisdiction, are going to be pro forma. They're always going to be requested. And it makes sense. If you think about what kinds of third-party opinions you're going to be asking for, you're going to be asking for opinions that are going to address legal matters, not factual matters, that the lender is either not able sufficiently or efficiently to address itself or with its own counsel, or to do so would be duplicative of the work of borrower's counsel that they're already performing. And we're going to get to entity opinions and enforceability opinions in a minute, but just on opinions generally, and by the way, the caveat is this is Rob on opinions. It's not as though there's any definitive Delaware law authority on what opinions are proper to request or not proper to request, but there's a lot of materials out there on a national basis that I try to reflect in the book. But if you think about what an opinion is, it's a reasoned professional judgment of how a Delaware court should decide the legal issue considered in the opinion, if the court were presented properly with appropriate information as of the date of the opinion. So again, my view is it's proper to request opinions and to expect the request for opinions in those areas where it's really not feasible for the lender to know certain things that are important for the lender's own diligence. So when we get to entity opinions, we can talk about that. Because one of those is the power to make the loan. The lender could get all of the borrower's entity documents and maybe with its counsel explore those and determine that yes, in fact, the borrower has the power to enter into the loan. But that's pretty inefficient because borrower's counsel is already going to be doing that, presumably, because they're going to be counseling their client as to whether it can do this loan, because presumably in the loan documents, they're going to be representations and warranties from the borrower that in fact they had the power to enter into the loan. So borrower's counsel is already going to be reviewing these things and working with its client to ensure that those representations are correct. On the other hand, insisting on opinions that are either an issue best known to the lender or are not cost effective, I think shouldn't be asked. I know this is heresy, but an example I think of the things that are best known to the lender, why in the world you ask them, is the example of a Delaware situated lender to a Delaware borrower for Delaware real estate collateral that the mortgage document prepared by that lender and used in that lender's loans for the last 20 years. Why are you asking the borrower's counsel to opine on that mortgage, that form of mortgage? I mean, it happens all the time. We know it happens. We agree to it, but it really doesn't make any sense whatsoever. Or in local counsel opinions, where you're functioning as a local counsel, giving an opinion on the mortgage, only on the mortgage and not anything else on the transaction. And you're asked to opine on whether the lender should qualify to do business in Delaware. Well, it's a lender that does loans all the time in Delaware, presumably has already looked into licensing and related requirements before it started doing business in Delaware. Better yet, it has an office that I can see from my office across Rodney Square. And so why are you asking me this question? And this makes zero sense to ask me this question. Anyway, that's it. I don't want to spend more time on those, but that's Rob on opinions.
All right, so the time's really flown by. We're actually pretty close to the end of the program, but we wanted to, unfortunately, we don't have time to get more into the Delaware entity opinions. If anyone's interested, please buy the book. But we did want to ask you about something that's not included in the book because of the time in which it was published, which is COVID-19, and whether you have any comments on business interruption insurance's effect on Delaware real estate and financing as a result of COVID-19.
All right, sure. There are a couple issues I think that have arisen in what we're talking about here with commercial real estate finance as a result of COVID-19. One is business interruption insurance and some of the practical issues. The other, if I have time, I'll touch on is material adverse change provisions in loan documents, or the reverse. Default if there's a material adverse change in the financial condition of the borrower. On business interruption insurance, back in the SARS outbreak in early 2000s, businesses looked to business interruption insurance to protect them from their losses, disruptions of business as a result of the viral outbreak. In reaction to that, a lot of insurers started excluding viral bacterial outbreaks from standard business interruption policies, which is the case now. Most of the forms exclude these kinds of causes of damage in order to allow you to collect. A lot of insurers have issued blanket statements saying, don't bother us with COVID-19 claims. So, there are a lot of issues here. And I think most owners who are trying to get business interruption claims are probably not going on the viral route, they're going on the governmental order route, which caused the disruption, and arguing that it wasn't the pandemic, it was the fact that you now have governors saying, you have to close 80% of your operation in order to comply with health safety requirements. And I know I'm working with folks that are pursuing those claims, but if you're the claimant, you got two threshold issues to get over. One is, does your policy even cover your claim? In other words, do you have an exclusion for viral virus losses that you've got to overcome. And the second is proving actual damages and not just economic loss. I'll point, there's an interesting North Carolina case from just a couple months ago where the court found that the loss of the use of the insured property as a result of government closure order was included in the physical loss coverage. So that's a pretty good case. And again, a recent PA case, it's not been decided yet, but there's some preliminary indications that the court might view the claims favorably under the same sort of thing, that this is governmental orders and creating this damage. And there are also some other cases. I know there's a recent holding in the United Kingdom, which is on point and pretty helpful. On the other side of this is, what happens, if I can't perform? Do I have an out? Well, in the lease world, we all have seen lots of discussion on force majeure clauses in leases, particularly early in the pandemic. And that's not really helpful for finance because most finance documents don't include a force majeure clause allowing the borrower not to pay if a force majeure event occurs because the bank wants its money. But I was thinking through that, and the fairly recent case in Delaware Chancery on the hotel sale that looked at material adverse change clauses and whether the seller could get out of whether the buyer could get out of performance because the sellers changed their business practices as a result of the pandemic. And in that case, the court said you can't get out of the material adverse change covenant, but there's another way of looking at it, which is that there was a normal course of business covenant that the seller had to be operating normal course of business, and that the pandemic ordered the governmental order changes that so changed the seller's business operation that they were no longer operating in the ordinary course of business. And I was thinking, what about the default in most loan documents for a material adverse change in the financial condition of the borrower or the guarantor? And if a borrower has to reduce its business by 80%, that's going to cause a material adverse change, and how are you going to be dealing with that? And so from a drafting standpoint, going forward, something that borrowers counsel might want to be looking at when they're looking at that particular default and thinking, okay, well, what if we're in another pandemic and how's that going to work? Should I get some sort of relief if this is something not because of my own poor operation, but because of circumstances that are imposed from the outside, whether pandemic or governmental orders?
Perfect. Well, looks like we have a question from the audience, and then any closing thoughts you might have. So this question just is going back to the question we had about third-party opinions. And the question was, is it reasonable for lenders' counsel to request enforceability of loan documents that the lender drafted?
I sort of touched on that, I think. It depends on the circumstances. In my example, which was the Delaware lender, Delaware property, Delaware borrower, Delaware documents, been using the same for 20 years, doesn't make sense. Versus a situation where a lender is coming into Delaware, new to Delaware. Yeah, they could hire counsel to look at their documents and make sure they're enforceable, but it might be more efficient for them to simply put that burden on borrower's counsel to say, yes, it's enforceable. I mean, it's certainly not a good practice for a lender to do it that way because the borrower's enforceability opinion is going to be far less useful to a lender than the lender's own counsel on what should be in that document and not in that document. Because the borrower is simply going to carve out everything under the sun and basically say, borrower's counsel is basically going to be saying, yeah, you can foreclose. Maybe in court, maybe in Superior Court, maybe in Chancery. Yeah, you can foreclose. I mean, that's the essence of what that opinion is going to end up reading. So I think it can be a reasonable request, and it happens all the time. I just find it odd, even though I know I've asked for it as lender's counsel in an intrastate deal.
Excellent. All right. Well, let me be the first to say thank you for telling us and for giving us the wealth of your knowledge during today's presentation. It has been an excellent session and I've enjoyed it very much. We do have a couple of quick housekeeping closing announcements. Thank you everyone so much for attending our session today. As I mentioned at the beginning of today's webinar, today's session is for CLE credit for Delaware. If you have not already provided your Delaware Bar ID number, please make sure to send it to support, that's SUPPORT @fastcase.com, so that we can make sure that your certificate has the correct information so that you can get your CLE credit. Please join us again for future sessions. We have a number of really great book authors coming up in the future. And again, thank you so much to our guest. It has been a pleasure speaking to you. And Morgan, do you have any closing thoughts as well?
I wanted to thank Rob sincerely for his time, and you definitely have a wealth of knowledge on this subject, and looking forward to working with you in the future on future editions of the book and any new projects you might have coming up.
Thank you. Thank you. And thank you all for listening in. Everybody stay safe and healthy. And if you're in Wilmington, don't go out when it gets icy tonight.
Great advice. Have a wonderful afternoon, everyone. Stay safe.